which we had a discussion concerning dockets, and one of the things that he seemed to be very supportive of is non-jury trials, bench trials. So inquire of your supervisors, and if they don't give you an immediate response, would you do the court a courtesy and let us know, and I'll call Mr. Gonzalez directly.
Your Honor, I brought this issue to the attention of the misdemeanor chief of the criminal trial division, Jamisa Jarman, in an email sent on October 16th of 2020.
Judge, we're on YouTube.
All right. At this time, the court will call case number 593026, State of Texas versus Christopher Sanchez. This is a matter when the gentleman is alleged to have committed the crime of driving while intoxicated. Second, said to have occurred on September the 16th, 2018. He is represented by, at this time, a second attorney. This one is Jessica Gonzalez. You're appointed to represent him, Ms. Gonzalez.
Yes, Your Honor. And for the record, I am here today, and as is my client. He has it on here as Christopher Days, but this is Christopher Sanchez, my client, Your Honor.
I am not quite sure I understood what you said. The file says Christopher Sanchez.
And that is correct. It's just that his name, as it appears in the Zoom text box, says Christopher Days, but that is my client, Mr. Sanchez.
Christopher what?
Days?
D-A-Y-S, sir.
Days.
Days.
Where the hell did that come from?
That's just what he has on Zoom. So I just wanted to make sure that you understood that that is my client. He's changed it on the screen. That is my client, Christopher Sanchez.
I
He
just
is present.
had it,
All right.
but they changed it.
All right.
Okay.
Mr. Sanchez, you are the same person that is identified in the file as Christopher Sanchez?
Correct.
All right. And just for the record, I don't intend to inquire from you any further, but be aware that you have a constitutional right to remain silent, which means you don't have to say anything, make any kind of statement. You don't have to answer any questions during this proceeding from me, from the district attorney's assistant, or from Ms. Gonzalez herself, unless you choose to voluntarily do so. Do you understand that?
I do.
Okay. Now, further, for the record, we are in the midst of a pandemic. So at this point right now, we're holding this portion of the proceeding on video conference. It's commonly called Zoom. You have the right to demand that this hearing be held in the open courtroom in public, or to continue on video conference, but that it be placed on YouTube at the request of your attorney on your behalf. This matter has been placed on YouTube, and it is public. People can just tune in and see and hear everything that's going on. Do you understand that's going on?
I do.
All right. Now, the issue at hand is that the defense has requested a bench trial, that is, no jury. The state has announced that under the circumstances at this time, his supervisors have not responded to his request for a non-jury trial. Is that correct, Mr. Edelman?
That is correct, sir.
And you made a statement earlier that you had made that or texted that request on October, you say 12th or 13th?
16th, Your Honor.
16th.
I transmitted it by an email sent on October 16th of 2020.
And today is October 29th. And you've
Yes,
had
sir.
no response. All right. And do we have any other preliminary matter that you wish to address at this time, Ms. Gonzalez?
Yes, Your Honor. I would just like the record to also reflect that my client did originally put in his demand for a jury trial on January 21st, 2020. The court had conducted a speedy trial hearing specifically on this matter on June 4th, I believe, of 2020, where the court did deny my client's request to dismiss for a speedy trial violation at that time. However, we were supposed to be given preference over a jury trial setting as soon as we were able to come back. As the court has accurately reflected, we are not expecting that jury trials are going to be resuming in any foreseeable future, just given the priority settings of the Code of Criminal Procedure and the fact that my client is out on bond. He does have bond conditions that have made it incredibly difficult and prejudicial for him to continue remaining on bond. And after explaining all of his legal options at this point, he has made the decision to waive his constitutional right to a jury trial and is ready to proceed on a bench trial. As Mr. Edelman had put on the record, I actually did file this request for a jury trial waiver. I believe it was actually filed with the court and served to the state on October 16th, 2020. And as the court accurately stated, we are now, I guess, 13 days, so almost 2 weeks as of tomorrow, since the prosecutor has sent this request and information to the supervisors. So we are asking that we be given the jury trial setting. If the state of Texas, wants to object to that, that is obviously their prerogative, and I will go and file the next motions that I feel my client is entitled to and request a hearing on those motions. But I feel that that I and my client, Mr. Sanchez, have given more than enough time for the district attorney's office to be able to come to this decision. And we need to go forward on this. My client is very anxious to proceed to a trial. He's willing to waive his right to his constitutional right to a jury trial because he does want this matter heard and resolved. So for those reasons, we are asking for the setting, or at least asking that the district attorney's office provide the court with an actual official denial or approval so that we can move forward. And we ask that they be given just 5 days to be able to provide this information to the court.
Very good.
Your Honor, may I briefly respond?
Yes, sir.
I know for a fact that Ms. Gonzalez is capable of contacting Ms. Jarman because I know that she has done so in the past in her position as Chief of the Misdemeanor Criminal Trial Division. So if Ms. Gonzalez wants an answer to this question, she can bypass me and ask Ms. Jarman directly, I should say.
And while that is an option, I prefer to go through the chain of command, and Mr. Edelman is the assigned district attorney to this court. So he is to answer to this court whether or not the state is going to waive or request and invoke their right to a jury trial.
And defense counsel has gone through the chain of command and not received any results in a timely fashion. So it may be time to go around the chain of command in order to get results, if results are what defense counsel wants.
Okay, now you were doing real well till the last bit of a comment, Mr. Edelman. Why don't I just solve this for you, and I, as a judge, will contact the head of misdemeanor and request a response, either pro or con, on the non-jury bench trial.
Sounds good to me, sir.
Alrighty. I guess, Patty, you can get a estimated or expected jury trial date for the defendant. It's going to be some kind of a weird date, I know, but we'll do what we can.
Judge, I was setting the cases that are 2010 and after to January and February and March. So
give Ms. Gonzalez and Mr.
Sanchez.
Sanchez an expected date. In the meantime, we'll get a hold of Ms. Jarman and see what we need to do.
Yes, sir.
All right. Then with that, anything further, Ms. Gonzalez?
Nothing further. I think the bigger question for the quarter, at least on our end, is whether or not the state is going to approve or deny my client's waiver. If I can just get a simple answer next week, I can go and we can proceed to the next steps of whether or not getting the setting, as the court was just saying, or I can file my motion. I just need the answer. Yeah. All I need is an answer, yes or no, next week.
That's understood, and I have committed as a judge to obtain some response from the head of misdemeanor.
Okay.
All right.
Is it
Anything
okay if
further,
we
Ms.
just
Gonzalez?
nothing further. If I can just email everybody next week and see if there's been a response. And then once I have that direction, we can get the appropriate settings.
Very good. Mr. Edelman, anything further?
Nothing further from the state, sir.
Thank you. Ms. Gonzalez, Mr. Sanchez, we appreciate your being here, and the court will discontinue this hearing as well. I'm reluctant to call it a hearing. Discontinue this proceeding at this time in accordance with what I have recited and what's been stated for the record. All right. You're
Thank you.
excused.